Let's take a look at a hypothetical in contracts. This is a 1-hour past bar exam essay, and it's fairly typical. The first thing I see is 2 calls. What defenses should Travelco assert on the merits of Polly's breach of contract claim, and what's the likely outcome? When it asks defenses on the merits, it's asking you to establish that the other side didn't make their case in chief, their prima facie case. So I'm going to frame things in terms of lack of offer, lack of acceptance, lack of consideration. Second, which items of damages, if any, is Polly likely to recover? So 2 things about that. One is that when it has a call like that, I'm going to look at the paragraph above these calls to see what items are there. How many do I have? And then, because I have multiple of the same thing, multiple items of damages here, I'm going to look for the legally relevant differences among them, and that's what I'm going to highlight in my analysis. So there's the paragraph. We see 5 items. First, the cost of listing the telephone number. Second, the champagne. Third, the luggage and clothing. Fourth, loss of her job. And fifth, the value of the trip to Scotland. So what do I mean by legally relevant differences? Well, these 5 things are going to differ in terms of how reasonable they are, how foreseeable they are, the dimensions that you look to analyze damages. Now we go to the top of the hypothetical and we start reading. And it says, Travelco ran a promotional advertisement which included a contest, promising to fly the contest winner to Scotland for a 1-week vacation. A promotional advertisement. And the prize is a trip to Scotland. So what's being offered here is a trip. That is not a tangible good. There's no sale of goods here, so the common law is going to apply. All right. What else? A promotional advertisement. We know that an advertisement is generally not an offer. And we see that this paragraph goes to the issue of offer. It goes on to say that the winner's name will be picked at random from the telephone book for this trip to Golfer's Heaven. All right. The UCC and the common law differ in terms of what constitutes an offer. In the common law, definite and certain terms means just that. In the UCC, just the quantity makes it definite and certain. So what do we need to turn an ad into an offer? We need an identifiable offeree. There's one winner. And we need specificity. This is a 1-week vacation to Golfer's Heaven. There's a strong argument that there's enough specificity, the terms are definite and certain enough for this to be an offer. Okay. After reading Travelco's advertisement, Polly had the telephone company change her unlisted number to a listed one, just in time for it to appear in the telephone book that Travelco used to select the winner. Does that constitute acceptance? It's really hard for me to argue that that would constitute acceptance because Travelco was not really bargaining for her to put her number in as a listed number, to change unlisted to listed. But you can analyze that. Luckily for Polly, her name was picked, and Travelco notified her. All right, so right there. Her name was picked and Travelco notified her. I can at least make the argument there that that notification constitutes an offer of a trip. So I'm going to analyze that as a possible second way there was an offer. Now the issue is, again, acceptance. It says that night, Polly celebrated her good fortune by buying and drinking an expensive bottle of champagne. So we've seen 2 items of damages here that she's asking for, but I'm going to deal with that later. I'm still looking for an acceptance here. I don't see any communication from her to them that unequivocally accepts their offer of a trip. I mean, she may have said something when they notified her, but the facts are unclear about that. So what about the next day Polly bought new luggage and costly new golfing clothes for the trip? They're giving us a lot of actions she took following the notification that she had won. So I am thinking about a unilateral contract here. Maybe they were not asking for her to literally accept, they were asking for performance. And so I would make that argument and analyze that. When her boss refused to give her a week's unpaid leave so she could take the trip, she quit, thinking that she could look for a new job when she returned from Scotland. That's the 4th item on her damages. After it was too late for Polly to retract her job resignation, Travelco advised her that it was no longer financially able to award the free trip that it had promised. Okay, has she accepted at this point? If she had already accepted, then they cannot retract their offer. But we're not being asked about anything other than defenses on the merits. So I'm going to try to keep my eye on the ball here and analyze offer and acceptance. The 3 items of damages contained in those paragraphs, though, are the expensive bottle of champagne, the new luggage and costly new golfing clothes, and she quit her job, which she cannot now get back. What am I going to do with all of this? I haven't seen a clear acceptance, but I can argue that it was a unilateral contract and that she accepted by performing. But I still have a problem with consideration, don't I? What's the consideration here? I see legal detriment on Travelco's side. They owe a trip. But what is her legal detriment? What did she offer up? She changed her telephone number, but they didn't really bargain for that, did they? So if I can't find consideration, I can't find a valid contract, what other theory can I use? How about promissory estoppel? They promised her a trip, and she relied on that promise. Now, what am I going to do in my analysis? I have 2 theories under which she could recover at least some of these remedies. One would be a contract theory. One would be promissory estoppel. And the damages she could collect would vary depending on which of those it was. So now, as I said, in call 1, I'm going to assert the defense of lack of offer. I think Travelco will lose on that because at the very least when they notified her that was an offer. I'm going to assert lack of acceptance. I think Polly has a reasonably strong argument that the steps she took, the actions she took, constituted part performance. But in any case, it's difficult to find consideration. If I'm working a 1-hour bar essay, I'm probably going to rely on promissory estoppel as the winning theory for Polly. And under that theory, the items of damages get clearer. Promissory estoppel and contract differ in the remedies. If you have an enforceable contract, you're entitled to your expectation damages, the benefit of your bargain. So that would include the value of the trip to Scotland, right? If you're relying on promissory estoppel to make your recovery, then we simply try to put you in the position you would have been had there been no promise, which means she could collect for the reasonable, foreseeable items that she bought relying on that promise, or the job she lost relying on that promise. The big one that differs is the value of the trip. Under a contract theory, she can collect that. Under promissory estoppel, she cannot. The other items of damages are going to vary along the lines of reasonableness and foreseeability, and that's what I'm going to highlight in my answer. Is it reasonable to buy luggage? Yeah. Expensive clothing? Not so sure. What about quitting a job, losing the job? Well, how reasonable is it to quit your job over a 1-week trip to Scotland? I would think that's not so reasonable and not so foreseeable either. So you see, analyze the differences among those items on those grounds, and you'll have all you need for your answer on a 1-hour racehorse on the bar exam. Now, as you work through these hypotheticals, it would help to have your outline for the subject open. But now, I've flipped this up the page so that I can outline for you what I would do here. Call 1. I'm going to analyze lack of offer, lack of acceptance, lack of consideration, or bargain for exchange. And since I'm not really easily finding consideration, bargain for exchange, I'm going to analyze the alternative theory of promissory estoppel. Call 2, expectation versus reliance damages. You can do these. Understand that in your practice, it's going to take you longer. When you head into a final exam or a bar exam, you will have memorized your core outline, the core law, and everything will be quicker, issue spotting and all, and you'll know the rules really cold. If this kind of content is helpful to you, please share it with your friends, with your classmates, with your fellow bar candidates, and like the video to help us with the algorithm. And I will post another issue spotting of a UCC hypothetical tomorrow.